to work with you on everything that I've tried to work with you on.
I had
You
just
get
got
to the
out of
point-
jail. I didn't have money. I don't have money for that. If I go to jail, I'm gonna lose my housing. I've been kicked out of therapy. Everything that it was helping, I've been kicked out of. I'm not able to attend my women's trauma group because I had court Wednesday. I had just got that started back after a year. I see my baby. I haven't seen her in 6 years going through this court stuff, them sending stuff to the
Ms.
wrong
Cartwright,
address. My baby gonna be 18. I don't have a natural
Cartwright,
parent
on
child bond
every
with my
case
daughter.
before me, I've tried to work with you. I have
I'm just not
not
getting the
appearing
paperwork.
on certain things. I've done everything I possibly can to try to facilitate the process for you.
If somebody
But I
pays
can't,
for it, I
if
don't
you
have.
want to keep interrupting me, you can keep interrupting me, but it's not going to get you. But the cold-hearted reality is that when you're given bond conditions, you have to comply. You can't just go over there and say, I'm not going to do it.
I didn't say that. I called my attorney and spoke with him and voiced my concerns with that. I'm physically not able to do that. I have issues, health issues with that.
Well, it's going to have to be
And
addressed.
I
before
can't
Judge Valvo
physically-
regarding her release. Defendant's bond is revoked. She's remanded to the Washington County Jail.
Excuse me, I'm gonna lose my housing, like, my rent and stuff is due. Well, can we talk again? Cause I didn't talk about this with you, Mr. Lucas. I got rent coming up, I'm gonna lose my housing, I can't see the daughter. What is this about? Like, what did I do? Please say something before I come back.
All right, then. 14. Court does call the case of the People's State of Michigan versus Martin Grice.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Graham, who stands to my right, please state your name for the record, sir.
Sir, I fired her, sir.
I'm sorry?
Represent me. I would like not to have this counsel represent me.
If I may, Your Honor, when I did speak with Mr. Graham this morning, after our discussion, he did state he did intend to proceed unrepresented today and without me as his counsel.
Are you going to, what's your basis, sir?
I looked in the law library on things that would get me off, Your Honor. However, no matter how much information that I gave anyone, my defender did not look into anything that would fight on my behalf. So if I was given time or just an accurate law library myself, I think I'd do better without them. They don't talk to me. She just came and talked to me for the first time, but 20 minutes ago. And I asked her what did she plan on doing to help me. She said that you're going to follow the prosecutor's recommendations, and the prosecutor did this.
Prosecutor's recommendation. Prosecutor's not recommending anything.
Well,
So she couldn't have said that.
not the prosecutor recommendations, the recommendations of the what was that, probation recommendations.
Mhm.
So I say she don't have any fight for me, so I don't need
Really?
someone that's supposed to fight for me.
He
That
doesn't
fight.
have any fight for you?
Oh man, no, sir.
So out of all the people that she represents, it's just you.
No, it's not.
That's funny.
It's not just me,
Well, do you want to represent yourself or you want me to get you other counsel? Because Miss Pate,
sir. I could try
very
counsel.
talented attorney, so she doesn't have to waste her time with you. You want somebody else?
Yes, I use somebody.
You do somebody else? All right. Then, Ms. Pate, you can file, I'll permit the public defender's office to withdraw. You can get, when you have time, and trying to do whatever I guess you don't do. What you can do is you can file the motion with the court or an order with the court and ask that the MAC office appoint counsel to represent it. There's no reason for you to waste your time. What date do we have for sentencing?
February 26th.
No, it's gonna probably take longer than that, so. Give me a March date.
12th.
March 12th, all right. Then I'll adjourn the sentencing to March 12th, 2024. it's a 9,
Yes.
at 9 a.m. And public defender is permitted to withdraw. And again, Ms. Pate, get that order into me after you speak with the back office. Thank you.
Thank you.
Monday, I did one case.
That's fine, John, you did.
No, it was one case. And all that happened.
Yeah, John. Thank you.
Mayor, today's the date and time set for preliminary examination. At this time, as case 24 FB 1431, the people are unable to see this count as that count to be remanded to district court. And in case 25 FB 1109, people to ask the court to add a count 2 of misdemeanor stalking. The PAC code 750.4118, and we are unable to proceed this to count 1. Would ask that count 2 be remanded to district court.
With regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges count 1 in both files be dismissed.
All right. In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed. Continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B4. Yeah, for in custody. Before I give you a date on that, let me.
We're going to ask the court for bond on that matter, Your Honor. So if you could just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking.
Correct, Your Honor.
In the PAC code on that.
750.411. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation. Good.
I'm sorry, Your Honor. My client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count 1 in that case is dismissed. I'll set pre-trial in these matters. All right. In both cases, pre-trial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they are, they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
So
Miami Avenue in Ipsy.
that would be his home address, Your Honor. I just didn't know whether the alleged victim was also at that address.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't. Is that all right? Okay. All right. So people's response.
Your Honor, we would object any modification about, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark your ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you with broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with today, but did recently on Friday and that she was on board. We have great concerns. But I also believe he has a holdout of Jackson County for child support as well, Your Honor.
If that's the case, I was unaware of that part. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, in regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client because he's been sitting in the Washington County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And these threats were from the police report, not from jail calls. They were from he sent the victim's phone that led to the charges.
So he was out. He was not in custody when he allegedly made these threats, and nothing happened to anybody. So Mr. Graham doesn't get insulted. What's running his mouth? Right?
When he's out, is he working or?
Well, he's been in custody for a while, Your Honor, I assume. So I don't know the answer to that question.
Okay.
Charge set up for April 1st, and I said it this misdemeanor, and they had on the prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was going to start April 1st. No, I think they need to go to bond, but she said she wanted to say after this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is the previous order prior to any release. Now, the only I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right. Thank you.
Just one moment. My client seems to think that the bonds are $50,000.
10% bid.
Did they get changed at some point?
The bonds I had originally were both 100,000 cash surety, but were not changed.
He's on 2 felony cases.
And then he has a misdemeanor case, so now he's saying that come out,
Yeah.
within 14 feet.
So he's
So
reducing
that bond that he's referring to.
No.
It's 100K cash surety.
Yeah, that's right. That's what I had.
That's for the felonies.
On these two cases, I had 100,000 cash surety on each case.
Let's work.
All right. Thank you.
Thank you.